The view is that over-reliance on consent is simply not very privacy friendly. It's often abused. She refers to it as the fair and reasonable test, which every organization will have to establish before they can, process personal information.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, we're finally gonna have a first episode covering Australia, which I always thought is a really sophisticated market for digital advertising, analytics, or marketing technology, but that may have been lagging behind in terms of data protection or privacy, or data privacy, as they call it. It is also a country where media publishers have been really powerful in terms of enforcing certain restrictions and even shaping new laws, and we have touched upon some of them in a few newsrooms, a few episodes here, but the proper legal angle was still missing. And here we have Alex Dittel to finally do it justice. Alex leads KeyHQ's data privacy, cyber and digital legal practice. He brings over 15 years of experience in data protection, information security and technology, working both in the UK and Australia. As a passionate GDPR-native data privacy lawyer, he advises on both Australia and international data privacy matters. Let's go for it. Alex, thanks for joining me.
Pleasure to be here. Thank you.
We've never covered Australia. That's a fact.
Yes, it needs to be covered, yeah.
What do you believe is the state of data privacy or data protection regulation in Australia today?
So, yeah, the Australian privacy regime is one of the leading regimes in the world. It is based on the Data Privacy Act 1988, which sounds like something that happened a long time ago, but it's been updated over time. I think three particularly notable reforms in 2012 when they finally included consolidated Australian privacy principles in 2018, where they had a data breach notification regime following massive data breaches that happened in Australia and really forcing Australians to wake up to the risks of the digital space. And in 2022, when the fines were increased to kind of GDPR level fines, but again, with a focus on the data breaches rather than the actual privacy framework itself. So this is the Federal or Commonwealth Act, which applies to private organizations and federal or again Commonwealth agencies. But the landscape is much more complex than that because every state has its own data protection act. And this act typically applies to state agencies, but also contractors who work for state agencies. On top of that, there are certain sectoral laws. For example, health data is under a separate regime in some states. There are also separate laws for surveillance at work. And there will be other regimes in the financial sector focusing on cybersecurity, for example. There is also the consumer data right, which is consumer law concept, and it's some kind of equivalence to data portability, and open banking is mostly associated with the banking sector. So there's a real mix of different laws, and that makes it quite a complex landscape to navigate. Australia, unfortunately, has been quite slow in recognizing the tort of invasion of privacy. Uh, it's literally only happened in middle of last year, 2024. Um, there was this case, and this only happened at the county court level in Victoria, and the court was very firmly acknowledging that there is a separate tort of invasion of privacy based on the equitable tort of breach of confidence. And this was kind of backed up by previous higher court cases, typically involving uh, some some really complex set of facts where a person, something was published about a person that that wasn't true and was damaging, often to do with the media. But yeah, previously the courts were really reluctant to find that there is a separate tort, and this was the first very firm judgment, really kind of welcoming that tort, and explaining why it is a part of the common law. And this is, let's be honest, 20 years after the UK, and it's even 20 years after New Zealand, the neighboring country. So it's quite remarkable that this hasn't happened earlier. And at the same time, we had the privacy reform in December, which actually implemented a statutory tort of invasion of privacy. But unfortunately, that comes with the typical exclusions, including an exclusion for media, which is a bit a bit surprising. But I guess that's what the political process here, uh, you know, uh, gives fruit to.
Why do you think New Zealand is ahead? For example, New Zealand is an adequate country. There's adequacy, right? If you look at the European Commission in terms of international data transfers, New Zealand is part of these countries that have an adequate level of protection, whereas Australia never made it to the list. Why do you think that is?
Well, I haven't studied the New Zealand system. I'm obviously in the process of getting a very firm grasp on the Australian system, but there are some very noticeable gaps in the Australian system. Um, as I said, there are a lot of laws. There's a complex web of laws. Sometimes they overlap, sometimes they add additional kind of sectoral duties, but the drafting, for example, of the Privacy Act 1988, it's full of exceptions. So, for example, the Australian privacy principles, they are not really principles. It's not like you have one sentence of principle, which is a firm guiding rule. It's more, like six paragraphs about this is what we'd like to happen, data minimization. But you don't have to do it if it's impracticable or unreasonable. So the law actually includes the words impracticable or unreasonable, and that's a very common trait. So this is something you would normally see in contracts drafted by lawyers. But here in Australia, it's common to have this in the statute, which then obviously weakens the position. And I guess it's a real feast for lawyers to find reasons and arguments to say that a certain rule doesn't apply, or it could be applied in this way, or there's this way around it, and we can still do what we need to do. And I think that's why the regime here is probably not seen as strong. And on top of that, there is a small business exemption. So 90% of Australian businesses are small businesses, less than 3 million Australian dollars turnover a year, and they're all exempt. So they don't have to comply with with the basic privacy principles, which is just remarkable. And also employee records are exempt. So this doesn't apply to employee data, which is already recorded and held in a record. So just as the lawyers are being very creative in saying why their clients can get around the rules and do what they need to do. Equally, the regulator is very creative in finding why certain exemptions do not apply and the rules should still be followed. So it's uh, it's it's very that yeah, it's full of legal nuances and yeah, it's definitely something that the lawyers have made a meal out of.
What changes are felt under this new privacy commissioner? What are their priorities after this recent change?
Yes, so the new commissioner, I think there was the outgoing commissioner has been very well known and she's done amazing work. Uh, and at the time of her departure, they split the function into the information commissioner and privacy commissioner. So really to, I think, give more weight, give more resource to each of these two elements. One being freedom of information, the other one being data privacy. So the privacy commissioner focusing on upholding the right to privacy is someone who spent a lot of time in the UK, and I think she has come with a lot of fresh energy and strong views about privacy protections, which clearly Australians want. And I think what she's trying to do is to focus on some strategic enforcement actions. And some of her determinations from 2024 are almost of normative value. Um, she's really trying to clearly say, look, this is the rule. This is how it applies. This is what you have to do. So, with the backdrop of all these kind of legal uncertainty of the legal text, I think she's trying to bring a bit of clarity into this and focus on some of the main privacy interferences which must be addressed.
So, what's the direction of Australian data privacy from your point of view? How is it? Where is it headed?
Yes, so it's obviously headed towards addressing the highest risks of in the digital space. But also, trying to innovate at the same time. I think the initiatives such as the consumer data right, open banking, that was really there to give customers more choice in their product. But it's a regime that didn't quite work out. It's criticized for high cost and no one is aware of it, so no one really uses it. And instead of the banking sector sharing data with other providers, with competitors, in order to give the consumer the right choice. Instead, many providers are still data scraping. So the consumer basically consents to giving access to their account, and then a scraper comes in and scrapes all the account data, and that's the way they get it. So it's a regime that totally failed. So it's an initiative that was well intended, and there are many well intended initiatives. Some of them work, some of them don't. I think the Digital ID Act 2024 is another initiative where they're trying to say that you can rely on digital IDs if it's sufficiently robust, and the aim is to reduce the amount of copies of passports that the public sector holds, right? To allow people really to go, this is my digital ID. You don't need a copy of my passport. So, really well intended regime. And there are certain laws on online harms, which is a entirely separate regime. So focusing on that, and I think Australia was quite early to have an online harms act. Uh, so it's really headed in a direction to address the biggest risk. You may have heard about the recent social media ban.
Yeah, for under 16.
Yes. So again, that's a very strong step to ban something and to kind of regulate it that way. So it is quite interesting. Where is Australian privacy heading? It's definitely a mixture of political ambitions uh, and what the Australian people want, but it's quite regrettable that the reform that happened in December only included a very small fraction of uh, the proposed reforms that the government had agreed to in a consultation paper. So it's a bit of a confusing space where you have all these different initiatives, but no one really wants to firmly focus on having one comprehensive law that would regulate everything, which would be much easier to navigate and perhaps would serve, Australians better than this fragmented, complex web of legal obligations.
I'm very skeptical of consent as a legal basis in many environments. But because of e-privacy, again, still dragging its feet in the EU, we're used to the annoying consent banners, or annoying to me. What's the status in Australia? Is there anything similar to e-privacy? Do you have any idea, any exposure to that?
Yes, so it's a very interesting regime. The concept of consent is very widely used, uh, relied on by organizations, but it's not really well defined. The Act doesn't really tell you what consent means. It says there's explicit and there's implied consent. So it opens door to implied consent. Uh, but I think even before considering that, you know, the Australian privacy principles, they don't have any kind of legal basis for processing. So they say an organization can process information if it's necessary for its functions or activities. So there is no, you know, analysis of necessity, proportionality, which is a very heavily relied on kind of a safety mechanism under the GDPR. And uh, and so many organizations believe that, okay, let's have consent just to be safe legally that we can do a certain thing. And then consents has started appearing in terms and conditions, general tick box to accept the privacy policy. So really all the bad practices that under GDPR you would say, oh, this is not valid, this is not lawful. We need to change it as soon as possible. So so the current practice here is to obtain consent at all costs, and because you can rely on implied consent, it really allows you to be creative and even sneaky if you want to be, and say that we have your consent, and to basically uh, mitigate your legal risk that way. But under the Privacy Act, you don't need that consent. You can pretty much do anything and everything without consent, subject to assessing necessity. Is it necessary for my functions and activities? So that's very broad. And again, this is where the new commissioner sees a big issue with the lack of any standard of processing. So where are the boundaries, and in the recent decision in relation to Bunnings, which is a popular and much loved local retailer, they deployed facial recognition technology. And in her determination, the privacy commissioner actually introduced the proportionality requirement under the Privacy Act, and she based it on the objectives of the Privacy Act. She said that the objective is to obviously uphold privacy, and you can't possibly do that if you don't have an assessment of proportionality in the mix of, compliance assessments. So she's trying to introduce this standard, and this is something she is pushing in the tranche two of the reform. She refers to it as the fair and reasonable test, which every organization will have to establish before they can, process personal information. But she's not waiting for the reform. She's already doing it in the determinations where she's normatively setting out, look, this is what the regulatory expectations are. You need to also consider proportionality. And the view is that over reliance on consent is simply not very privacy friendly. It's often abused. It's often uh, taken out of context and relied on disproportionately. And people don't understand that they have given consent, so it's not seen as a viable option. But it is the prevalent kind of legal ground that organizations rely on in Australia to process personal information. So it's a big job that she has set for herself to change that culture of consent and say, no, there is another standard, it's objective, and when it comes to standard, we have to kind of follow closer what the kind of GDPR says on consent, which is, specific, informed, valid, given by a person with uh, who is capable of giving it. And so yeah, there's a lot of change in this space coming.
I also understand there's no such thing as legal basis in the Australian regime. So you're talking about fairness, and you're talking about the Balancing Act, and in my head, thinking of the legitimate interest three-part test, but it's not legitimate interest. It's just basically applying the fairness principle and using some sort of similar proportionality test. Is it, or is there already something that resembles the legitimate interest legal basis?
So no, there isn't, but the commissioner in her determinations is introducing, proportionality based on the objectives of the Privacy Act, because this is the other kind of noticeable difference between the GDPR regime and the Australian Privacy Act. There is no overarching human rights law that sits on top. Um, the GDPR has the benefit of human rights law, and this is how the UK found that there is a sort of invasion of privacy in 2004, and it didn't take that long to arrive at that conclusion. Whereas in Australia, it's taken so long because the only human rights law is a political covenant from the 50s, and it was ratified, I think, in the eight and in the 80s, but it never went through the parliamentary process. So many courts were not seeing it as a part of the Australian legal system. So the right to privacy doesn't sit at the constitutional level, and that then leads to all these problems with interpretation and legal creativity when it comes to that interpretation.
Do you find the Australian legal system equiparating, or do you find that the notion, the concept of data privacy or privacy is the same as data protection in Australia, or do they make a difference as we do in the EU?
Uh, so so yeah, I guess it's a play on words a little bit. They refer to data privacy, um, and obviously then there is privacy. So, invasion of privacy, I guess it's slightly different to data privacy. Data privacy being focused on personal information. So there is a difference, but yeah, obviously they don't use the word data protection. So the words are more similar, and the concepts are perhaps often seen even closer together. But in fact, there would be a difference, obviously, for data privacy being focused on personal information. Uh, and I think I also wanted to add one other thing, which is quite different and perhaps more similar to the US approach. So data privacy is not only enforced by the Privacy Commissioner, but also the Consumer and Competition Authority. So the ACCC has taken significant action against Google and Meta in the past for misleading and deceptive conduct, which quite resembles, the FTC approach in the US. So even if an organization doesn't, finds their way around the Australian privacy principles, they still have to be trying to avoid, being deceptive and misleading. So that's another factor, another complexity in this legal system, which is again the result of, continued plea for lesser regulation. But the end result is you have more regulation because you have this patchwork of different initiatives instead of saying, yes, we're happy to have one comprehensive law and we'll work on that. But that would never be accepted by businesses who want less regulation, and it would be very hard politically, I guess, to push through. So yeah, the end result is a complex and fascinating web of legal rules that organizations have to navigate.
Thank you, Alex. Very interesting. Thank you.
Great. Thank you. Thank you very much for having me. It was a pleasure to be here.
Okay, that's all for today. Follow us on Blue Sky, and in the Masters of Privacy Altogether profile, you will find the starter pack, which includes the feeds of all of our past guests. There is also a Masters of Privacy LinkedIn channel, which I invite you to follow, where you will find links to our transcripts, cheat sheets, and other surprises every now and then. Our main website is mastersofprivacy.com. Thank you for listening.